Hello everyone, this is Tom Fox and I'd like to welcome you to episode 176 of the FCPA Compliance and Ethics Report. The FCPA Compliance and Ethics Report is sponsored by Advanced Compliance Solutions, a one-stop shop for all matters compliance related, compliance policies, programs, training, videos, and general expertise in the area of anti-corruption compliance. Today we're in for a real treat. I have as a guest Tim Treanor. Tim is a partner at Sidley Austin. He was the lead counsel for PetroTiger in their FCPA internal investigations and in negotiation with the government, which led to the rather astounding result of a declination being issued to PetroTiger. This declination came even though three senior executives of the company were directly involved in the bribery scheme. Tim talks about the underlying investigation, his investigation protocol, and most importantly, what he was able to do to help PetroTiger receive this declination. The episode comes in at just over 22 minutes. I hope you enjoy it. Thank you very much for listening. Hello, everyone. This is Tom Fox, and I'd like to welcome you to this episode of the FCPA Compliance and Ethics Report. Today, I am very pleased to have with me Tim Treanor. Tim is a partner at Sidley Austin, and he has a lot of experience in the white-collar area. But the thing that I wanted to visit with him about today is he was lead counsel for the company PetroTiger in their FCPA investigation. And he got what I thought was just a stunning result for his client of a declination. PetroTiger has been in the news lately for some of its former executives and officers, but what I really wanted to visit with you about, Tim, is your role for the company and what you did and how you got this, what I think is just a fabulous result. So with that somewhat long-winded introduction, welcome and thank you for coming on.
Thanks a lot, Tom. Appreciate it. Always happy to be able to talk about the work I do when the result is as good as this one. So thanks for the opportunity.
I guess maybe if you could tell the audience a little bit about your current practice in white-collar defense or white-collar work.
Sure. So I spent close to a decade in the U.S. Attorney's Office in the Southern District of New York, and came out of the office, joined Sidley Austin in 2008. And have been practicing in the white-collar space since then. A couple of years ago, the firm made me one of the co-leaders of the practice group, and we do a wide range of we handle a wide range of representations, represent companies in FCPA matters. We've got a number of other significant engagements. We represent an international bank in the FX investigations. We have a LIBOR panel bank. We've been representing Soccer Confederation CONCACAF in connection with all the FIFA matters.
Wow!
So we're doing pretty good these days. Busy though.
It sounds like some really high quality work and some really interesting work you're doing as well.
It is. We I suppose my only complaint these days is. We try to have a mix of institutions and individuals, and, we do represent some individuals, but I haven't been getting into the courtroom all that much, and I miss it a little bit.
Well, as a recovering trial lawyer, I certainly understand that.
Yeah.
Let me turn to PetroTiger. Could you sort of walk us through how you or the firm were retained and kind of what you did initially, or steps, and then how did you go about your investigation? Because really, the how to do an investigation is something a lot of compliance practitioners have questions about.
Sure. Well, we at Sidley, we were actually advising PetroTiger in connection with corporate governance matters. So we had a relationship with the company before the issues that arose from the FCPA investigation were known. And what happened was essentially there was a struggle between the three senior managers who are now the three individuals who are convicted of FCPA offenses. But those three individuals were in a struggle with the private equity firms that had bought significant stake in the ownership of PetroTiger, and were serving on the board of directors. So the outside directors were struggling with management, and Sidley was doing some things, corporate governance type things. We were involved in setting up an audit committee for the company, and ultimately that internal struggle, which related to integrity issues, resulted in the outside directors pushing management out of the company. At that point, they conducted a review of more of a general review because they needed to get an understanding of what was going on within the company in terms of financial obligations, and wanted to know about all the existing contracts and simply needed to get a handle on things. And in the course of that process, some of the payments at issue were identified, and I was asked at that point to conduct an internal review and advise the company on what I was finding.
Could you talk about the steps you took, beginning perhaps with how you thought through your investigation protocol, how you executed that investigation protocol, and then when you made a final determination or you had the results, how did you make the presentation to the relevant parties at PetroTiger?
Well, the protocol is for an investigation like this is pretty standard. I mean, nothing is always the same in this area of practice, but in general terms, you want to once you know you've got an issue, you want to secure your evidence. First thing you want to do is make sure that people know they can't destroy documents, that you put a hold on your electronic evidence, and that so that when you go and look at things, it's going to be there. You're not going to have lost evidence. That's a very important step also if you ultimately are involved in discussions with the government, to be able to say, we believe we've suffered no loss of evidence. We've preserved everything. So we did that first. And then, of course, we took a look at documents and financial records, and we had identified sort of areas of inquiry and crafted targeted searches, and we were looking for certain financial transactions. And once that was done, we had a body of evidence that enabled us to conduct effective interviews, and then we spoke to the knowledgeable people, at least those who were still remaining at the company. As I said, the managers had been pushed out of the company, so and they were also the individuals who were involved in the misconduct that we identified and fleshed out, and so they were not available for full interviews by us, but we interviewed other individuals, and once you get through that process, you've completed the bulk of your investigative work, and at some point the decision was made for us to report to the Department of Justice, but obviously before that we were reporting to the Board Audit Committee and giving them briefings on what we were finding.
Could you walk us through one question that many compliance practitioners always put to me, which is, what factors do you consider in the decision to self-disclose or not? How would you as outside counsel help a company come to that decision, whether it be up or down?
Well, that's perhaps the toughest decision that needs to be made in these kinds of cases, because you really have three potential outcomes. One is that you don't say anything to the authorities, and hopefully nothing ever happens. Nobody ever knows about it. That's really a pretty desirable result, even if you're a responsible company and you want, you're aggressive about remediating and you're serious about these things. It's nice to not have to go through the reputational harm that can result from an FCPA enforcement action, or to have the restrictions put on you. So, that's one outcome, is do nothing and hopefully nothing happens. The other extreme is, the government finds out before you tell them. That's probably the worst position to be in, because then you've got a government agency that may not fully trust you, even if you've done work internally to review something and to remediate. You're sort of on your back foot in the discussions from the get-go. And the middle state is you self-report, and then you engage the government and you work to get the best result. And for a lot of companies, I think that boils down to trying to figure out whether the government is going to ever learn about the issue that you have, although that's not always the case. And, and And there are a lot of other factors. Some companies just don't have a risk tolerance for keeping these things internal. Some board members will make decisions themselves that they would like to see these issues aired out, no matter how much trouble they cause for the company. Sometimes issues are not of significant magnitude, and the belief is that the process can be managed in dialogue with the government. And other times you may have actually found problems and have defense. You may have a statute of limitations defense. You may have a jurisdictional defense. And so you may self-report and then go to work trying to convince the government that there is no offense. So there are a lot of factors, but you do have to, one of the things you have to look at is the government, the DOJ or the SEC, if you're an issuer, are they going to find out about it? Because if they are, the decision's pretty easy. You really should be self-reporting to get in front of it. If they're not, if you think they're not going to find out, well, then you have to explore more deeply the other factors, and that really is the risk appetite of the firm and generally people's attitudes about self-reporting. Sometimes you get people who just want to do the right thing. So there's a host of factors. Every situation is different, and really any good counsel will, pile up the pros and cons and walk the client through. This is what could happen. Here's, my view of the likelihood of, that an issue will come to light independent of anything we do. You may have to assess whistleblower risk, the risk that some story might hit the news, or, maybe a competitor will, make allegations. There are a host of things that can happen that can bring an issue to light, and counsel just needs to walk the client through, and ultimately the decision is the client's with advice of educated and experienced counsel.
Tim, if I could, I'd like to turn to the results that you got, or PetroTiger got, I suppose would be a more accurate way to phrase it. But why would you believe that this decision on behalf of your client, PetroTiger, was among the most favorable corporate decisions, certainly in the FCPA context and perhaps in an even broader context?
Well, I think there's a pretty simple answer to that question, and that is the fact that you have the two co-CEOs and the general counsel directly implicated in the offense conduct. And, you don't get more senior than that in management. And, the conduct was squarely within, the area of practice of the company. It was in the company's interest. It was for purposes of securing an oil and gas oil field services contract. There were no jurisdictional questions, really. There was no statute of limitations defense. And so, you have a firmly established offense right at the highest levels of management, and this company got a declination. And so, I think that makes it a pretty unique example of the results that, companies can obtain. But, it stands somewhat alone. I mean, it's in a category with Morgan Stanley, perhaps, although even there you didn't have the CEOs and the general counsel. You had an investment banker.
Right. Well, how did PetroTiger as a corporate entity escape charges? And then perhaps could you opine on the way this case indicates a trend of individuals rather than corporations being at least charged with FCPA violations?
Well, in terms of how the company escaped charges, I can't obviously speak on behalf of the Department of Justice. They made the decision, and it was their decision to make, and they did not give me an explanation for, their actions, nor did I ask for it or expect it. And, of course, we were thrilled with the results and very appreciative of their willingness to listen and to accept the arguments. But I do know the arguments that I made, and I have feelings about which ones I think were successful. And I think there were a bunch of factors in this case. I think one of the critical factors in my mind was the struggle between the managers and the board. We were able to show very clearly from early on, and, if you're familiar with the Siegelman case, Joe
Sure.
Siegelman was charged not only with an FCPA offense, but also with a a wire fraud charge for side payments related to the acquisition of what became the PetroTiger company. That was the first transaction that the private equity firms were involved in with PetroTiger, and they were defrauded by the managers, by their business partners. And then thereafter, when the company was established, the managers were not disclosing accurately the financial condition of the company to the board. The board was very aggressive in demanding disclosures and in trying to institute reforms to put in place code of conduct. There were allegations. There were other problems, including the fact that the senior managers amended the budget without approval from the board and presented it to the board as if it had been the original budget. So there were all kinds of problems that the board members were dealing with, and they were at the same time aggressively trying to ensure that the company was operating cleanly. And board members actually interviewed employees when there were some allegations of misconduct, to the extent that they were banned from the corporate headquarters by Mr. Siegelman. And so we were able to establish a struggle that showed that the board members were not turning a blind eye to misconduct. They were not interested in profiting from corruption. They, in fact, were very aggressively trying to establish an environment of integrity. And that coupled with the fact that if you punish the company, and the board members forced the managers out. They forced them out and bought back their shares at about 18 months into the existence of this company, which was an incredibly aggressive move. And so ultimately the private equity firms and the representatives were the owners of the company, and they're left holding the bag. So we argued, I think very convincingly, that if you punish this company in any way, you're punishing, you're re-victimizing, the individuals who the managers had, treated improperly, consistently, and it's not going to serve any purpose. You're really just going to heap on more misery on people who, frankly, you could not have expected to do more under the circumstances. And I think that argument was very effective. The offense conduct was not the crime of the century, of course. It wasn't the largest FCPA offense that we've seen. So that was, I think, another factor. And I think all of that amounted to a compelling story that a declination was appropriate. And another aspect of it was, PetroTiger operates in a regulated environment where reputation is very important, and a declination would do more to ensure that this company can move forward with a record that is not going to be harmful to its performance as a business, as a legitimate business, whereas even with a non-pros or a deferred prosecution agreement, you sort of have the scarlet letter, and that, you're a company that has engaged in misconduct, and that could have been financially damaging to the company, and again would have served to punish only the people who really did the right thing, self-reported, investigated, sought to have an effective compliance regime within the company. And so I think the mix of arguments. One last argument that I think was effective is the fact that programmatically this was good for the Department of Justice. And, we tried to convince them that a declination would be good for them, and I actually think it is. You've got a situation where a company that is largely a foreign company, although they had a small office in the U.S., with conduct that is, not unlike other FCPA cases, but is almost entirely foreign conduct, and in all likelihood would not have been known to the Department of Justice. But these companies, these private equity firms and their representatives on the board decided on behalf of PetroTiger to self-report. And, if you hit a company hard under those circumstances, that's not going to look so good. That's not going to encourage other people to come forward. On the other hand, if you treat this company well and say, you know what, you can have two CEOs and a general counsel who are convicted of FCPA offenses, but because the other, sort of governance leaders in the company were doing all the right things, you can still end up with a declination. That sends a great message, and that's going to encourage people to work hard on having strong compliance regimes and respond aggressively to misconduct, and may encourage more companies that might not otherwise self-report to do so. And I don't know how persuasive that was for them. I certainly think they would have thought through these issues themselves without me raising them, but I think they were also effective aspects of the decision-making here.
Well, you engage in what we down in Texas call creative lawyering, and sounds like excellent arguments you made with the facts you had to work with.
Yeah.
We're getting near the end of time, but I wondered if I could maybe end with asking you to look into the veiled future a little bit. And what do you see as the impact of this decision on FCPA enforcement, and even more specifically for corporate executives, investors, and legal counsel going forward in the compliance arena?
Well, I think that this is cause for hope for people in the FCPA bar, that we have a Department of Justice that will listen. I know some people in the past have felt that there aren't enough companies that get favorable resolutions, and here's a pretty strong example of one in which the department was willing to listen, willing to sort of operate outside the boxes that they had created previously with resolutions. It was not, when I asked for a declination, it was not like they granted it right away. We had to go through a process, but to their credit, the individuals involved were very willing to listen, not closed-minded at all about this. And to me, that gives me a lot of hope as a practitioner. I think that for me to work hard and try to bring out the areas that reflect favorably upon my client and warrant, leniency for my client, I feel like we have a department that listens to those things. At least in this example, that is very much true.
Well, Tim, unfortunately, we're now at the end of our time, but I was wondering if anyone wants to follow up with you or... Hello, everyone. This is Tom Fox again. I'd like to thank you for listening to this episode of the FCPA Compliance and Ethics Report. I have two call to actions for you. First is, if you could go to iTunes and rate this podcast, I would greatly appreciate it. The second thing is, if you have any questions, I am developing a list of questions for my next mailbag episode. So if you have any questions, please send them in to me at tfox@tfoxlaw.com. Once again, thank you for tuning in on this episode, and look forward to visiting with you on episode 176. Thank you very much.
Thanks, Tom. Appreciate it.
All right. Thanks again.
Take care.